I should get myself together. What order
So who are we missing? We begin again. Let me first assure you that I will end this at 3:30. And you can be absolutely sure of that because I've got to bolt to the airport. So self-interest is your interest, but I think there'll be ample opportunity for people to chat outside and so forth. The final panel of our day is entitled Policing State Corruption and the Relevance of Transnational Justice Issues. Once again, a very distinguished panel, Larry Backer, Paul Carrington, Adrienne Davis, David Gray, Jeffrey Meyer, Christiana Ochoa, and Anita Ramasastry. I propose that we go in the order that they have been listed, which I think follows the English alphabet. Let me just say again as a way of preamble to this, I think this panel is going to expand our peripheral vision a little bit. We have been talking all day about odious debt, but one way of looking at the world is to say that under the genus of state corruption and mismanagement, there is one species, namely odious debt, but it can be viewed in that taxonomy if you wish to do it, and that the broader issue is state corruption and mismanagement, and if one could find effective tools to deal with that problem, perhaps it would necessarily follow that the odious debt problem would itself also diminish in significance. Let me follow the same process we have all day, ask our panelists to give brief introductions, then we'll turn it over to their discussion and your discussion, and I'm going to do it in exactly this order with David first.
Oh, you're going in the order.
Oh, no, forgive me. No, you're right. Larry, I'll do it, Larry first. You're first.
All right. Well, thank you very much, and thank you all for sticking around to the bitter end. We will try not to make it easier rather than harder to sleep through at least my 5 minutes. I'm going to talk about how Fidel Castro and Hugo Chavez and the current Ecuadorian president, who's going to make you a lot of money, will be very good for business, and that is for the business of lending to sovereigns, even as they begin to create in more authoritative versions notions of the systemic illegitimacy of the entire capital market system on which lending to sovereigns is based. So what I'm going to talk about is I'm going to give you a perspective that is not the usual one, and indeed the one that we've been talking about all day and that we'll continue to talk about in 4.5 minutes. A perspective that is essentially Western, that is essentially hegemonic and creditor-oriented. A system which essentially focuses on the maintenance of stable global capital systems, after all, that is what we've been talking about all day, within a family of nations, again, talking about that not as we understand it in its nicey formulations after 1945, but as we understood it much more dramatically and brutally in its formulations before 1945, that is a system of a hierarchically ordered family of nations in which the lower rung nations, semi-sovereigns, are increasingly brought to a civilized state through a number of mechanisms, including the discipline of financial markets. The method by which we in the West have shown our good feelings, our sense of the civilizing notion of this has been evidenced in a number of ways. One of them is the odious debt doctrine, originally meant both to discipline, that is, to ensure a logical mechanism for or rationale for the repayment of any kind of debt, but at the same time providing some sort of very, very narrow focus for fairness, that the system itself is not legitimate because somehow there's this door that you can open up. between the beginning of the 20th century and its end, of course, that has opened up dramatically. And much of our discussion today has been on the ways in which it's opened up, whether those ways are legitimate enough, real enough, authoritative enough, legitimate enough. And they fall in 6 categories. We see a movement from the old SAC system in the 20s to a focus on the will of and the benefits to territorial sovereigns, that is, to the people. The problem is obviously a sensitive one, we're told, and there are requests to consider odious any debt that has been incurred by a government without the informed consent of its people, one that's not used in the legitimate interests of the state. Although this is currently not the position of positive international law today, is we're moving in that direction. It makes us feel good. The second is an adherence to the basic contractual context of the transactions and the consequential emphasis on lender and borrower due diligence, as well as contractual obligations. And indeed, much of what we've been talking about today has been in the language of either aspirationally or in real terms in this contractual language, even though we're talking about sovereigns. The third is a shift of responsibility to lenders with a move away from the state and the borrower obligation to lender responsibility and a greater willingness to tolerate the imposition of significant penalties for the failures of lenders to monitor the use of their funds. Again, we're talking about this opening the door to fairness, all of which is meant to ultimately discipline and civilize these rambunctious groups of poor countries that can't help themselves but borrow for all kinds of reasons. For the deepening of the notion of the passivity of the polity and a greater willingness to excuse a failure to act in the face of oppression or illegitimate conduct on the part of those who control the state apparatus. The poor Iraqi people, of course, were nothing more than blank ciphers until the moment that they were liberated by the coalition of, I forget what they're called, but the coalition of the people who went in, and the people, and
they're called the willing.
That's right. That's right. They are called willing. All kinds of people have been willing to do all kinds of things for a long period of time in all kinds of ways. But anyway, so the people of a jurisdiction are required to do nothing to evidence their disagreement with the practices later used as a basis for repudiation. People kind of exist as this thing, but it's very passive. Unless they were around in the US in the 1770s. The fifth, an embrace of the idea now rationalized that odiousness is universal and not contextual. In some circumstances, even the populace may not legitimately undertake obligations to engage in certain activities funded by debt to which the state is later bound to repay. And lastly, a sharpening of the autonomy and distinctions between the legal personalities that constitute a state. This is really re-bringing back the old Bractonian notions in a very bizarre way. The difference between the state, its government, and its functionaries as 3 distinct legal personalities, each of whom might, under particular circumstances, wind up holding the bag, that is, the borrowing bag, of the money that the creditors would very much like the state rather than its apparatus or its functionaries to be responsible for. And last, an extension of the applicability of this doctrine of odious debt to all public obligations, even those of sitting regimes. In contrast to that, in the paper, I have an extended discussion of how these notions, these Western notions, have now been flipped, especially in the writings of Fidel Castro, although he represents the quote-unquote leftist groups, the socialist or command economy groups, that suggest, yeah, we agree with all of these things, and indeed they're great, but in a sense, what you really ought to do is not turn it on the borrower, you got to turn it on the creditor, and not just on silly banks, who may or may not be stupid occasionally, but on the credit system itself. And that indeed, if you do that and you apply if you apply all of these notions to the system itself, you'll see that countries borrow because they must, and they must borrow because the system is set up to require them to borrow in order to stay solvent or to continue to function, and that therefore the system itself is odious and illegitimate, and on that basis all debt should be repudiated and reputable. And of course, everyone goes, oh my God, they laugh, this man is insane and he's about to die anyway, so who cares? Except he has a number of acolytes, and there are a number of, in the form of Hugo Chavez, who has money, and opportunistically in the form of other regimes in the Middle East. While it appears to be either hysterically just worthless or unenforceable ever, except by crazy people down in Brazil in Porto Alegre and that man whose book that Hugo Chavez shook at the UN. For capital markets and for lenders, it actually, I believe, represents a great opportunity, an opportunity to use these notions now bound up in odiousness, corruption, coercion, complicity, popular benefit, monitoring, and transparency, to create a series of norms, terms, and presumptions and safe harbors that essentially will, I believe, once these terms become more current, insulate future lending from any objection on the grounds of odiousness and illegitimacy. We will, no doubt, if the banking and the lending community is smart, will begin looking for just Kogan's terms, interest rate limitations, payment terms limitations, covenant and condition limitations, safe harbors. By analogy to usury and unconscionability terms, they will create presumptions of popular benefit based both on the democratic nature of the government and the relationship between that government and the bank. They will shift responsibility to responsibility shifting model rather than a repudiation model, and they will set up safe harbors limiting the notion and defining and limiting out the notions of complicity. And I've run out of time, and thank you.
Thank you, Larry. Thank you. Paul?
I'm misplaced here. I'm ignorant of international law and corporations and creditors' rights and a lot of the other subjects we've been talking about. And I come to you as a member of the American Trial Lawyers Association to tell you that we got an answer to all this. We just sue the bastards, and particularly the rich ones. And my paper is about ways in which that sort of approach might have some appeal to those who want to regulate the conduct of not only of banks, but of other people who deal with weak governments, particularly in those places. The crisis problems are in areas where there are natural resources and poor people. And the corruption that results from that kind of connection is almost irresistible. And what I suggest is that there ought to be some way to try to bring some of the American model of trial litigation to bear on those kinds of problems. And there are models for it. The particular characteristics that are features of the American private law enforcement mechanism are the contingent fee, the American rule, you don't have to pay the other side's lawyer if you lose. Discovery, you have a power to investigate the facts and find out what really happened. And you also have access to public documents that bear on matters at hand. There's some other things, class actions that might be thought about, but all of this is an engine for private law enforcement, which is very valuable. It's relied upon by Congress, it's relied upon by state legislatures to enforce a vast array of laws. And corruption laws sometimes fit that description, and indeed I'll just briefly describe the False Claims Act, which was enacted by the first Congress of the United States in 1789. It's been elaborated, it's been modified, it's been upgraded, but basically the idea is that any citizen of the United States can come forward and identify himself as a relator who is there to bring a suit on behalf of the United States of America. And he's suing some rascal who has cheated the United States government. And if he files that case, you keep it quiet for a little while so the U.S. attorney can decide whether they want to take it over or not. But that's a 60-day period. Either way, the case goes forward. The relator remains a party to it. If the case is successful, triple damages will be awarded, and the relator will get a substantial slice of that, depending a little on what his role is, 15 to 25%. So if you can catch somebody who's cheating the United States, that's the way you do it. And there are now at 500 cases a year brought in the federal courts by relators who are alleging various, certainly historically, the big ones have been in the weapons industry, but now it's the healthcare industry that people are suing regularly for misbilling the Department of Health and Welfare. And there's one big case, $1 billion suit against a university for its fraud on the education program, So anyway, that's a model. And if you want to think about ways of dealing with corruption that includes a lot of the things that we're talking about here in regard to odious debts, this is an alternative way of thinking about it. And I've tried to elaborate a little on that in my paper and projected some guesses. Obviously, we can't just bring everybody into the U.S. courts, but if you're thinking about a model for a way to deal with a lot of this misconduct, I suggest that the American experience has considerable value.
Thank you very much, Paul. Adrienne.
Like everyone else, I am deeply indebted to Me Too for being here. And what my paper does is it joins two debates that I think on their face seem to be pretty disconnected. It's the slightly older debate about black reparations for historic injustice for U.S. slavery, and the much newer, or some people have pointed out, the perhaps revitalized odious debt debate on the more contemporary injustices involving the international debt crisis. Now, facially, I think these would seem to be quite different debates. One group of people is seeking payment, one group of people is seeking to avoid payment. One's about historic injustice, one's about contemporary injustice, one is about a racial group that was pretty much an innocent victim of another racial group, and with the sovereign debt crisis, in many instances, of course, we have ethnic minorities victimizing their own people. It's sort of Frederick Douglass versus Idi Amin at some level, right? These seem to be very, very different. But I want to join the two debates just to make hopefully get some analytic traction. First, both of the debates, reparations and odious debt, rest at the cusp of, on the one hand, highly specific moral and political injustices and crimes, and on the other hand, much broader maldistributions of wealth and resources between, on the one hand, blacks and whites, and on the other hand, between developed and underdeveloped nations. Correspondingly then, and this is part of what I find interesting, within both debates to address reparations and odious debt, we find two quite different sets of proposals, and obviously by necessity, because of time, I'm really caricaturing things, but today what we've seen are a vast array of sovereign debt restructuring mechanisms, many of them located in private law doctrinal modes, trying to find within existing private law ways to remedy and address rather grand historic transnational injustices, and the equivalent in black reparations debates is some people have tried to also find in conventional tort doctrine or in unjust enrichment doctrine a way to justify black reparations claims. At arguably the other end of the spectrum, we find more broadly sweeping proposals to use odious debt or reparations calls to issue more sweeping indictments of these injustices, which decline to separate them out from the broader effects of colonialism or structural racism. And so we've had discussions today about whether we should or should not be separating out the excessive or overhang debt overhang from more narrow odious debt. And we find similar things in reparations. Now, I think that both of these literatures have been quite innovative and have made important contributions to sort of legal literature and legal theory, and as well as private law thinking. I just want to note two, I think, of the particular benefits of the private law approach. One is that it insists on, in both of these debates, it insists on the fact that what is at issue is repairing past and or ongoing wrongdoings, not global charity. And I think that's such an important contribution of trying to frame it within private law. A second, I think it was latent today, I think it became quite explicit, benefit is an effort to try to tackle problems of historic and structural injustice while at the same time trying to rehabilitate private law, or perhaps some people might say sort of test the limits of the capacity of private law to address various sorts of injustices or to influence market norms and practices. I want to end just with two concerns I have about the debates as currently structured. First, and I think these are things that I think people have been saying over the course of the day, but first, the narrow set of proposals, the private law set of proposals, they obviously end up leaving determination of the question of what comprises undemocratic debt, which if we didn't know before, certainly by the end of today, we know is an inherently subjective test. It returns this determination right back to domestic U.S. courts in most instances. And in other work, I've also opposed turning to U.S. courts as the arbiter of black reparations. Now, I don't have time to go into this, but I just want to suggest that perhaps there's more than a little bit of sort of post-socialist pessimism that's masquerading the guise of pragmatism, and I think it would be interesting to talk more about why the turn to domestic legal institutions at the expense of trying to revitalize or to vitalize international political ones. My fear is that part of what we may be doing is actually exporting and normalizing even more so many of the norms that were part of the problem with both odious debt and to a lesser extent with reparations. My difficulty with the broader proposals is that they slide frequently, I think, into whole-scale distributive justice analyses, which I am all in favor of. But I think that part of what both odious debt and reparations calls put on the table is the need to make moral judgments about the specific historic injustices in question here, right? And that's part of what David Skeel calls the moral bite, arguably, of odious debt, and also, I would say, of reparations discourse. Now, again, I'm the last person to say distributive justice is a bad thing, but I would prefer to consider it and call it such rather than to try to dress it up as odious debt analysis or reparations analysis.
Thank you very much. David.
In deference to time, I'm going to bypass my obsequious intro on Me Too and just move straight to it. So in my view, the current odious debt debate deals with three interest vectors. The first of them is fundamentally a moral interest on the part of debtor states who don't want to repay and think that they ought not to have to repay because the debts were secured by their blood and sweat, but they didn't get any of the benefits. And that strong and I think gut appeal of that moral argument is what drives a lot of the post hoc attempt to use domestic law doctrines and international law doctrines to find some legal basis to vindicate that moral intuition. But there's a countervailing moral intuition that comes from lenders saying, well, look, we gave this money in apparent good faith. We provided the country with the opportunity to do things that they otherwise couldn't have done. We've been put out, and we have a right to be repaid. And intermixed with all this is a lot of the interest that we heard this morning in a stable and predictable international financial market, which it is argued services both lenders and debtors simply by being stable and predictable. My paper, and I got, and the papers on this panel argue that while problematic and troubling enough, those problems are myopic in terms of the real issues that are at stake in any odious debt context, which is to say in particular that odious debt debates come out of a broader circumstance of transitions to hopefully democracy, but at least transitions from an odious regime. These odious debt contests don't come up in the face of a continuous regime, although in some of the papers earlier, it seemed to be to me that a really, really sly, odious regime would say, well, look, all of my former debts were odious, so I shouldn't have to repay them, and we'll just move on. But as it stands, these only come up in circumstances where there has been a transitioning of regimes. And so my paper argues that any treatment of odious debt has to take account of the broader issues that come up in transitions, and in particular, the demands of transitional justice. And my paper argues that those interests, all three of the interests that underlie odious debt as it's traditionally construed, and broader interests of transitional justice, are best served by rejecting absolutely a negative claim of odious debt that would entitle a state unilaterally to void its debts in favor of an affirmative doctrine of odious liability that can be imposed on international lenders and financial institutions based on their complicity in the odious activities of the former regime. And I will just briefly go through the main moves that are in the paper and invite any questions during the period that follows. First, the paper describes broadly what the issues at stake in transitional justice are and suggests that once you start looking at the breadth of activities that odious regimes, as a shorthand, engage in, you realize that there's a broader taxonomy of odious debts than just debts of corruption, or even rather than just bank loans. There are all kinds of sweetheart resource extraction deals that odious regimes are wont to engage in. There are all kinds of infrastructure and development projects that ride on the back of human rights abuses in Burma and Chad are two contemporary examples. And when you start to add up all of the engagements that odious regimes have with international financial institutions and the breadth of their evils, you come up with a much broader taxonomy of financial obligations and other obligations that might fall under the auspices of a broadened odious debt doctrine that understands its role in broader transitional justice debates. And once you start to do that, you also have to take on board a lot of the absolute imperatives of any transitional justice program, and my paper identifies two of them that I think are at the top, and they are truth and justice in terms of recognition for past victims. And the core suggestion of the paper, which one reader has described as unsettling, and I in the paper say is nauseating, is that, as a matter of fact, odious debt doctrine, by providing a successor regime the opportunity to unilaterally void the debts incurred by their predecessors, is of a kind with indulgences in oblivion and marginalization of past victims, which is to say that past regimes are not led by a very small elite who put their boot on the throat of a country, but more frequently, odious regimes do what, in all, if you take the whole spectrum of indigenous cultures into account, what you would expect them to do. That odious regimes express the will and express the beliefs of a broader abusive culture. And that if you allow a successor regime to put the burden of its debts, as it does the burdens of those past acts, on an elite few, you ignore the complicity of the broader swath of the population. And you deny full recognition to victims, and you build in the promise of revisionism and perhaps a return to the old ways. And that the only way to really service transitional justice is to take full account of everybody's complicity in past wrongs, and that includes international financial investors, international institutions, and investors. And in so doing that, the best way to vindicate that, is just to revert to a doctrine of corporate liability for human rights abuses, and that services the moral impulse that debtors have without compromising those transitional justice goals. And I blame everybody else for limiting our time.
David, thank you very much. Jeff.
Thank you. I just want to follow up on what Paul said and try to describe, convince you that it's just as important as well as looking at odious debts to look at odious payments, that is corruption, transnational corruption, payment by international companies to a corrupt regime, and considering to what degree can we facilitate remedies for the people and the innocent people who are harmed by that. I came to this from the context of having worked in the investigation of the UN Oil for Food program. There's essentially three lessons from that I think matter to today's discussion. First, transnational corruption is alive and well to a staggering degree. Our investigation discovered more than 2,200 companies have paid almost nearly $2 billion in kickbacks to Saddam's regime just during a 3-year period. Secondly, we were able to demonstrate that there is actual harm in effect on the people of a country. Why is that? It's because the companies that pay these kinds of kickbacks, like good profit maximizers, end up recovering the price back, recovering what they pay back in the price, the inflated price that's charged. And therefore, in Iraq's case, that meant almost $2 billion less in the escrow account that was supposed to fund humanitarian purchases. I think we can generalize and suggest that transnational corruption, generally, the price will be passed on to the people of the later regime. And also, the third lesson that we have that we discovered long after we completed our investigation at the end of 2005 is that governments don't prosecute. There are very few prosecutions that have resulted from the Oil for Food debacle, notwithstanding the Oil for Food Committee's, Volcker Committee's release of thousands of pages of records and access to law enforcement authorities in dozens of jurisdictions worldwide. Not, to my knowledge, not a single company that paid kickbacks to Saddam's regime has been prosecuted. And were we talking about companies we've never heard of? No, we're talking about Daimler Chrysler, Siemens of Germany, Volvo Construction Group. These are among the companies that paid tens of thousands, in some cases more than $1 million each of kickbacks. The single largest kickback payer in the oil for food regime was an Australian company, the Australian Wheat Board. Now, there's been an active civil investigation so far in Australia concerning the Australian Wheat Board. But the fact is, there have been no criminal indictments more than 15 months afterwards. And I think this underscores Paul's point, and a point that Dan Tarullo made back in 2004 in an article in Virginia Journal of International Law about we can have these conventions, we can have the FCPA, we can have the OECD Convention on Bribery, we now have the UN Convention Against Corruption. And we find that they're interesting frameworks for combating corruption, but the actual effect in terms of what they've done has not been much. So the question is, where do we go in terms of what are the challenges in terms of realizing a private cause of action? I'd suggest that, for one thing, apart from the odious debt conversation, we eliminate the need to worry too much about whether the whole regime is odious, or whether the debt itself is odious, or whether, as Anna is concerned about, whether there's even debt here. In the case of a private enforcement action, a private damages action, typically in the U.S. court, you have a corrupt payment that you're working with. So the ill and the bad is defined here. We also don't have the problem of wondering whether it's a state successor government, or whether it's a successor government, or just a successor country or a successor government. This would apply in any case in which there's been some kind of a regime change. The challenges that come up that Paul, I think, hints at is, what's the vehicle? We don't have a real vehicle that's designed for this purpose yet. We have the possibility of the False Claims Act. Query, though, whether that's appropriate in case that's more for the whistleblower context, typically, than for the actual victims of corruption and fraud to take advantage of. We have a well-established history of human rights litigation, of course, using the Alien Tort Statute and later the TVPA, the Torture Victims Protection Act. That's another possible cause of action. But there are various, which I can't go into now, possible jurisdictional issues, possible cause of action limitations on the use of the APS after the Supreme Court's decision in Sosa versus Alvarez-Machane. There's RICO even. In fact, the one suit that's been filed by Iraqi victims, Kurdish victims, class action lawsuit against the Australian Wheat Board and against the main UN bank, filed just at the end of last month, is filed under RICO. But again, is RICO really an appropriate mechanism, an all-purpose mechanism for furthering these kinds of private enforcement actions? And the challenge right now is to, in my view, is to address how can we promote those kinds of private enforcement actions as a complement to the odious debt remedies that we might see in the future. Thank you.
Thank you so much, Jeff. Christina.
Thank you, and thanks to Me Too and the Journal, and also to the students who've organized this conference. I've found it tremendously stimulating, and I really appreciate that. I want to describe just very briefly how I came to the issue of odious debt, because I only came to it fairly recently, and I'm still working through where I'm going to enter the debate. I came to it through my work with our law school center on constitutional democracy and plural societies, where we're working with the Burma democracy movement in drafting a optimistic constitution for the event that the current regime may be ousted someday. And my connection with that, with the advice that we're giving the Burma democracy movement, is really to those provisions of the Constitution that deal with international law. And the question that I was initially approached with was whether or not the Constitution was properly drafted when it was drafted to allow the successor government a clean slate in respect of all treaties. And after some analysis, it was pretty clear that that was not necessarily the right approach or the best approach for them to take. So in conversation with them, it became clear to me that what they were really concerned about was all the litany of financial contracts, the financial engagements that the current government has entered into during the time that they have been in power. And that was not just the debt contracts, but also a whole litany of other types of financial contracts. And here I think that mine and David's approach might overlap. And that's in the observation that there are a variety of mechanisms, of course, for odious regimes to raise funds. So after assessing what I could garner of the contours of the odious debt doctrine, I've taken a position of some degree of skepticism and concern about the odious debt doctrine, because as many have pointed out, the odious debt doctrine will have an effect of raising the cost of borrowing. And as some have pointed out, this may have the effect of reducing the amount of borrowing that some countries, especially odious countries, will seek to do. But as Adam mentioned in the last panel, this reduction might in fact have in turn, if the effect of this reduction in borrowing might in turn have the effect of reducing the cost of credit, and that might be a net wash. But I also see another possibility, and that's the countries will look to alternative vehicles for raising funds. Some of these alternatives, like taxation, have already been mentioned today, but there are others, of course, and these are actively being carried out in a number of countries, of which Burma is one. And that's in the form of land concessions, assignments, and outright sales of natural resources and other valuable property and assets of the country. And so my approach has been to look at what it is about debt overhang that is particularly onerous, and then focus on the moral component of that conversation, right? The part that makes what is onerous debt, in fact, odious debt. And so I've looked at some of those components, like, and just to mention a few of those, the people had no voice in the taking on of the debt. The people had received no benefit from the proceeds of the debt. The people may actually have been damaged from the proceeds of the debt, or the way that the proceeds of the debt were put to use. And the lender may have benefited from the lending that acted to the detriment of the people. And it becomes fairly clear to me that in many instances, these criteria overlap quite nicely or are present in contracts for assignment, for concession, or for sale of natural resources and property and valuable assets. And it seems to me that that has both short-term and long-term problems that are associated with this, with the effect of shifting fundraising strategies. In the short term, it may have the effect of, in fact, funding human rights and humanitarian law abuses with the pillaging of natural resources. So you're, in fact, compounding, you're taking a human rights problem or humanitarian law problem and compounding an environmental degradation problem as well. And I think that's a short-term consequence over which the international community may have very little ability to affect, especially in an insulated government, perhaps like North Korea or Burma right now. There's also a long-term effect, which is that in the event that there is a state succession, you again will have a situation in which there are outstanding contracts and obligations, financial obligations, that raise similar moral concerns, the ones that I listed as well as others, that very similar to the moral concern that odious debt raises, will make it very difficult for the government, for the successor government to function, or to, at the very least, provide any sort of robust government services. So looking at these conversations about odious debt, I'm thinking about the spillover consequences of this doctrine, or non-doctrine, depending on your view, and what those spillover consequences could have on these other types of contracts. And I'm also looking for places where the characteristics of the odious debt doctrine, as we've been discussing it, can be mined for application to these other methods of fundraising.
Thank you very much. Anita.
Thanks. Like Christina, I should begin first with a thank you, but then also some confession in terms of where I come from. And I may sound like I have an axe to grind against banks, but I'm a former bank regulator. I used to work at the Federal Reserve, and unlike people here who did more lofty things, I used to chase international bank criminals. BCCI was the first case that I spent time working on, and wasn't that glamorous, so just a lot of papers sitting in a room in many places. And I also spent a couple of years dealing with Swiss banks with respect to Holocaust and World War II era bank accounts. So with that in mind, my paper is called Odious Bankers, ? And I focus on the issue of whether it's complicity or complacency in aiding and abetting when we talk about the role of financial institutions in transacting with odious regimes. And I'm mostly concerned with the way in which banks and financial institutions can either directly or indirectly through just loans in general or through loans for particular projects or endeavors can aid and abet international crimes or can aid and abet things like asset stripping and looting because they become the fences or the repositories for the assets. So I'm interested in the roles of banks both as lenders and creditors, but more importantly, I think, and the emphasis should really be on what happens to the money once it leaves a country. My work is situated in a larger debate that's going on in the international scene now with respect to the term corporate complicity. The United Nations has its global compact, whether it's a good or bad thing. One of the tenets is that that businesses should be avoid being complicit in human rights abuses. And I think most of the emphasis is on either odious regimes or unfailed states. John Ruggie from Harvard Kennedy School is the Secretary General Special Rapporteur who is looking at the issue of corporate complicity more generally and trying to figure out by looking at state practice. And my research looks beyond the United States to jurisdictions all over the world to say, is there an expanding view in domestic jurisdictions that businesses should be liable either civilly or criminally for aiding and abetting serious international crimes? And we're talking here international violations of international humanitarian law, genocide, torture, et cetera. So with that in mind, there are two ways in which financial institutions historically and in contemporary context can be said to be potentially complicit. And the word complicity itself, just like odious debt, is really fraught with problem because different people will draw the line in terms of what constitutes aiding and abetting either criminally, morally, or even civilly at various points on the spectrum. And if you look at comparative law and try to understand the concept of aiding and abetting, there is no universal definition, as well as looking at what kind of intent a legal person such as a bank or a business entity might have to be called complicit when it comes to an activity. But with respect to lending, I think it's very difficult to characterize banks as complicit in the acts of a dictator or oppressive regime. But there are examples. If we go back to the Second World War, two bankers were prosecuted by the U.S. military tribunal at Nuremberg. One of them was a private banker, Karl Rasche, who actually provided or approved financing for the construction of concentration camps. He was acquitted of those charges because the tribunal said bankers are simply making profit, that the idea of lending is simply a commercial activity and therefore is not illegal. And he was convicted for other offenses. I think if you looked at variety of cases today that Rasche would probably be found liable or guilty if he were prosecuted before an international tribunal today for that same activity, providing financing with direct knowledge that the money was being used to support something like the construction of a concentration camp. And indeed, with respect to, there's been a recent Dutch prosecution of someone named Van Anraat with respect to providing chemicals so that the Kurds could be gassed in Iraq. But you also have the case of South Africa, and you have private financial institutions there that provided investment as well as lending support to the apartheid government. And here you have the Alien Tort Claims Act litigation, which is going on, which poses a much harder case, I think, because that line between complacency and complicity is one here where the mere presence or investment in a regime that has been declared illegal by the international community is a harder case to make. Is the presence there supporting and financing a particular regime something that should be sanctionable? And I think in my own writing I say that presence and even presence and financing at that level is something harder to give sanction to. But what I'm more interested in is the role of banks as basically fences, that you have a problem of corruption and you have a problem of looting, and you have debtors, odious debtors, who move their money offshore. And there you have judges in a variety of jurisdictions who have begun to look at the role of banks and to sanction them using a variety of mechanisms. Many of you are probably familiar with Riggs Bank and the fact that both the United States Treasury Department fined it for engaging in money laundering and also concealment of Pinochet's assets. In addition to the United States Treasury Department, you also had the Spanish magistrate, the same one that indicted Pinochet, actually indicted several of the principals of Riggs Bank, again, for aiding and abetting Pinochet's concealment of his assets. And so there you see, I think, a very useful way of thinking about banks as potentially being complicit. You have, with Marcos, the Swiss banks, again, were at least in dicta described as agents of the Marcos family when it came to movement of assets out of the Philippines. And this is in the context of an Alien Tort Claims Act suit. And then you have the oil for food litigation and the use of civil RICO in the United States. And each of these are different tools. And so there's been an emerging movement among jurisdictions, not just the United States, for judges and for litigators to use domestic tools, criminal and civil, to begin to deal with the role that banks and business entities play as accomplices to odious regimes. And I think that much greater emphasis should be placed on this as a way of keeping the assets from leaving the country. And that may seem simplistic, but to the extent that you have problems and you want regimes to not fail and to be able to repay their debts, it seems to me that rather than us debating whether or not the debts are legitimate, that the funds and the coffers shouldn't be drained in the first place. Thanks.
Thank you very much. We have a limited amount of time, but I'll open the floor to questions. Paul?
I just want to underscore a point that Jeff made, and that is, if you rely upon public officials who have political careers at stake to enforce these kinds of principles, you are relying on a very slim reed. And last month, Prime Minister Blair canceled the prosecution of a British weapons manufacturer that apparently bribed the Saudi government. Apparently the Saudi government told Mr. Blair, cut it out. We don't want you messing around with our guys. And so he ordered the prosecutor to dismiss the prosecution. And sort of the point of my paper is, if you really are serious about this, you want to put the hands of enforcement in private citizens who do not have political interests at stake when they are trying to enforce the law.
Thank you very much. Friends? Yes.
Oh, so just sort of building on Paul said, though, if I'm a private lender and you're always say, look, there's an easy way to do this. Have the government, if the government's not going to have the political will to step up to the plate and sort of do sort of what David and Ted are saying, like ban investment, ban direct investment. Don't come after me ex post. I mean, basically, your failure of political will is what's the problem here. These are all sort of second, third best mechanisms. So at some level, is it really the problem that the government just lacks the political will to sort of identify ex ante which regimes people shouldn't be dealing with?
Are we not responding?
Before I take your question, would anyone like to respond, or David wants to?
I would just say that that's Sartrean bad faith. Investors, as was suggested by at least two of the other panelists, and I'll echo it, is they have a duty of due diligence as to the purposes that their investments are being put to. And they cannot, of course they do. And in a world where we have more robust enforcement of concepts of corporate liability for complicity in human rights abuses, they will affect that due diligence. And so what we ought to be doing is inserting into the international financial system incentives for corporations to bear that responsibility with all of their resources.
Yes, sir.
I think Paul Carrington and Anita Ramasastry have pointed out something that's very important. Of course, prosecutors lack the political will. But in the Spanish case, it was not just Baltasar Garzón, it was the private prosecutor that Spain permitted, Joan Garces, who came in. There are many diplomats who refuse to go to certain countries now where they might be prosecuted for human rights abuses. Private corporations, as the Burma case shows, share the liability, but not the immunity of the sovereign. And so even without a transition, you can go after the behavior. And so it seems to me that the common thread here is the search in the field of odious debts, as there has been in the field of international human rights, for forums in which these concepts can be developed and put to use. Because the example is that where those forums have arisen, there's been concrete progress in shaping behavior.
Thank you very much. We have time for one more question. Yes, we have it.
What about the circumstances where, and we've seen this in the 80s, where the government actually encourages and influences and pressures banks to make loans? How does that then factor into any defense that a lender, a private lender might want to avail itself of?
And
I don't know anything about how these deals are structured, but if a nation state is leaning on a private institution to engage in that kind of conduct, couldn't they insure them? Couldn't you ask the nation state to insure you?
I mean, I can give you a concrete example. The concrete example is, so we have Mr. Gorbachev in the Soviet Union, whom the Americans wanted to support, but didn't want to do it directly, so they encouraged the Germans. The Germans encouraged German banks to lend to Russia. That is why when the Soviet Union fell apart and the question was what to do with the debt of the former Soviet Union, the G7 very strong-armed Russia to assume all of that debt. in its own name, and then there was a restructuring of it, but the German banks who came to the table felt particularly aggrieved because they felt that they had been led into this, encouraged to do this by their own government, and therefore that you will, if you follow the history of these things, you will note that while there probably had been 20 Brady debt restructurings, when Russia did its deal in 1997, it was not a debt reduction. It was a stretch out, but no Brady haircut, as they say. And in part, it reflected that.
I think maybe the question is slightly different. Instead of German banks dealing with the poor Soviet Union, perhaps we might be dealing with American or intermediary banks who, at the behest of the first Bush administration, is feeding Saddam regime with gas, which is then used to subdue the Kurdish population in order to keep him and his war machine going against the even eviler Iranians. And then all of this comes crashing down when, through circumstances, Panamanian type circumstances, there's a change of regime. Now what happens to American banks in this global regime, because they're not controlled by the Americans anymore, it's controlled by the Americans and their friends, this global regime of harmonized standards in which, of course, the Americans will come out just fine, but their creatures, the banks, may be unhappy and ultimately won't fall into the same mistake again, or will always be at risk.
Thank you so much. Friends, we have come to the end of our time, slightly over. Let me thank the panel for a very stimulating discussion and turn it back over to our host.
And actually, we'd like to be able to continue this discussion because I know we're ending a little bit earlier than we had initially planned. So if the panelists are able to stay, we'd appreciate it. We have to thank you, Mr. Buchheit, because he has to catch a plane, as well as some others. So thank you very much. Students at the back table have information for transportation. And we have about 25 minutes for more questions. So.
Are you moderating?
I'll take the questions, I suppose, yes.
There may not be any.
There may not be. Does anyone have any others? Yes. Yes.
This is more an observation than a question, but I think I have a question too. The observation is about its connection actually between the two presentations that followed each other, the Davis and Gray presentations. And linking things like transitional justice, black reparations, and odious debt. There's a nice counterpoint there which deals with some of the questions that I think are at the background of these issues with regard to what's the morally right thing to do versus who's going to have to make payment, in effect, for things that happened in the remote past that, as people in the black reparations argument want to say, nobody was around today who was responsible for that, but obviously there's a kind of shared societal responsibility, and how do you deal with that? And it may be an answer as well to the bankers' questions about odious debt, that, you know, the risk falls on those who are, in a sense, best able to afford it, or at least harmed by being forced to bear what is a loss all around because of what's happened. But the question that sort of comes out of Anita Ramasastry's presentation, if we're going to have odious bankers, we may also want to think, and this is a direct and perhaps immediate threat to those of us who are lawyers, some of us who may have worked for banks as their lawyers, about odious banks' lawyers and professional responsibility issues. And I don't ask this question, you know, totally jokingly. I mean, John McCloy, who before he went on to greater fame as the sort of post-war consul general of Germany and lent his name to another law firm, before World War II, at another law firm, was essentially the lawyer for all the bankers who were the lenders to Hitler's Germany and Hitler's war machine. And revisionist history has sort of brought that out. He was hailed as a great man, when he was in his later years. But it does raise questions about, how the realms of responsibility sort of radiate out, because supporting all of this are, other people who are helpers, rating agencies, accountants, people who are involved in the larger enterprise of
providing the infrastructure for sovereign debt and sovereign lending. And where does the responsibility stop?
I nicely noted the connection. In fact, turns out I have a paper on conceiving reparations as transitional justice, so I completely appreciated all that David had to say. I think part of, and I'm not someone who does work on odious debt, but I've so appreciated all the papers. I think that part of my desire to locate these judgments in more international institutions is precisely in some ways the legacy of other moral horrors we've seen, like slavery, like the Holocaust. And so I would, as a first cut, begin to suggest that it's much easier to find, especially today, emerging international consensuses that puts people on notice, which I think is part of what David's point is. So that, and David Skill raised this, Skill and Boughton raised this in their the earlier draft of their paper, that I saw the question of antebellum slavery in the U.S. And so certainly, if you, not even certainly, but by 1850, there was a profound international question about the morality of the slave trade and slavery. There were certainly also questions within the United States, but when you remove the question from from domestic courts or domestic institutions to the international arena, I think that's part of where you really begin to get some sorts of consensus. So that's part of my fear about the very pragmatic solutions of we already have private law doctrines that we can just harness, but our history as being able to separate self-interest, political and economic, from moral considerations is not a terrific one.
I just wanted to respond to the question of where do you draw the line, and I would agree. I'm troubled by looking at pure investment or lending activity as something that could cause international sanction or prosecution, because I think it is really difficult. And even in failed states or even in odious regimes, I think that there's a role for legitimate business activity. So where I think one needs to focus is on looking at equivalence to civil prosecution and to using money laundering statutes and others to deal with financial institutions, particularly as repositories, and that there are steps before you get to prosecution which involve increased due diligence at the front end so that the money never gets into the accounts in the first place.
Yes.
In the Texas savings and loan scandal, no lawyers wound up in Club Fed, but a number of lawyers wound up dipping into their malpractice policies for having misadvised savings and loans and permitting them to flush the money out the door. You put that together with the law of parties in international criminal law, which says there's no defense of superior orders. And all of a sudden, that becomes an interesting question for law firms to think about. I say that as someone that chased Pinochet's assets for 30 years and finally pinned him down in Riggs Bank.
Professor Meyer, did you have a comment?
Yeah, I was wondering if maybe Anita might be able to expand a little bit on what current protections are in place in terms of if a bank, for a bank to guard against some bad dictator transferring money out to his Swiss bank account, what kind of protections are already in place?
Well, until recently, and we were having discussions in the quarter about this, but because of heightened scrutiny with respect to terrorism, you're seeing much more vigilance now, that you have regimes, the United States Patriot Act is one example, where banks now have to do heightened due diligence with respect to correspondent bank relationships, and also there's a new category of politically exposed persons and their family and friends that you're meant to do greater diligence on. That doesn't stop the bank from taking the money, however. It just means that you have a greater record in the event that there's a regime change and you want to find it. And I think that's still problematic. For those of you, I don't know, many people have read Eva Jolie's work, but she is someone who has dealt with corruption in France for many, many years. And she supports a regime where you actually put the burden on a politically exposed person to substantiate the source of their funds before a bank accepts them. Now, I don't know economically whether that's going to ever be an efficient solution, but it's a very interesting one.
And I should take a moment to identify Mike Tiger for anyone who doesn't know. Thank you. Anybody else have questions? Great. Well, thank you everyone for coming. A couple of small logistical things. If you need to ride back to the hotel at 4:30, there's a shuttle that will be outside to take you back to the hotel. anyone who has a flight today or tomorrow, if you need to meet up with your students, we'll be out at the back table if you want to confer with us for information on transportation. There's coffee outside now as well. And the papers are now in the editing process. About half of you have heard from your editors. The other half will hear from them next week. And if you have any questions, please be in touch with us. Thank you very much for coming.
I may see you over there. You'll be in the bar.
Yeah.